how does one distinguish between civil and criminal liability in tax laws? Like, I understand that there is, if you are just paying your taxes late, for example, there could be, in an ordinary case, interest will be payable.
Right.
Now, in which cases do the penalties kick in? One is that if you dispute the audit report, which raises the demand.
See, the penalties, for example, customs has at least 10 to 12 provision for penalties.
Okay.
Service tax has at least 5 provision of different kind of penalties.
Okay.
Right. So it all depends on a very factual position. If there's a penalty for a misdeclaration, there's a penalty for non-registration, there's a penalty for non-amendment. A lot of cases. I recently dealt with a case wherein this entity shifted its premises from A to B and forgot to update it in the records, right? In the registration certificate, and started taking credit of the services which they received in their next premise, and the department disallowed it, stating that you are not receiving input services in your place of provision of service. So these are very technical points which come into the picture, and on a very fact basis, they determine whether it's a penalty. Now, the basic idea for determination is this: that if the department can prove that there was an intent to evade tax, that is where your criminal fines would come into the picture. The law has been recently been amended where there's a prosecution to the person who's handling the finance department. It's very important for all the businesses to know that taxation earlier never had an imprisonment provision. Now it does for tax violations. The directors, the CA, and the finance directors can be sent to jail in case the department comes out with a conclusion that you evaded tax even after knowing that you were supposed to pay that tax. So that intent part is very important. Also, all these acts, excise, service tax, and customs, and VAT, also has a provision that anything done in good faith would not attract penalty. But as I said, at a departmental level, to establish that you did not have anything to do with this is very difficult. And only if you have proper records, even if you have proper communication in place, would you be able to substantiate that everything was done in good faith, right? That is why I always advise my clients, and it's an unsolicited advice I would like to give all the listeners today. In an indirect tax regime, whenever you're taking a position in terms of taxation, which might impact your rate of taxation or your taxation, or might raise a dispute in future, always write a letter to the department disclosing your position which you have adopted and ending it with request to receive a clarification or a statement from them. So it can be a one-pager letter stating that we have manufactured this good, we are classifying it under A category, which is leviable to X% on ABC basis. Request you to respond with your comments.
This should be written to which person in the department?
Just ideally, just go deposit it in the dark, take a receiving, and come back. Because invariably, 9.9 out of 10 cases, department will never respond back. And once they raise a show cause notice upon you 5 years or 10 years or 20 years down the line, all you need to disclose at the time of adjudication is that letter with the receiving. So you can be at least sure that there's no penalty whatsoever upon you because your bona fide is proved. And I don't think anybody for the fear of department coming on to them does that, but knowing how government functions, they would never actually respond to any of these letters because they think they have much more important work to do, and it would just be sitting in your files without any. It's a good strategy to adopt.
Minimizing the risk.
It's yeah. Your risk is at least reduced by 60 to 70%. Just make sure, do not address it to the chief commissioner and send it across, because invariably what will happen is it will reach the chief commissioner will mark it to additional commissioner, and it will get back to the assessing officer, and he will have no other option but to respond to it because it has come from the chief commissioner. So just write it to your assessing officer, address it to him, put it in the dark, and forget about it.
And you'll take a receipt basically.
It's of no use if you do not have a receiving.
Yeah.
And maybe keep it in your safe deposit locker and forget about it.